anti-money laundering or know your customer laws often say, well, you should collect as much information as possible and then monitor it to see if anything looks funny so you can investigate further, which on its face seems in direct contrast to this idea of proportionality and data minimization. And again, going back to kind of the fundamental truths of the jurisdiction, if I go to an organization and I tell them, oh, do not follow your anti-money laundering law because of data minimization requirements, they're going to say, no, you're going to get us on the blacklist and we will not be able to do business anymore. It would damage the reputation of the jurisdiction itself. And so that's just a non-starter. So again, we have to say, okay, taking for granted that we must accomplish this purpose, how do we do it in a data protection preserving way? And so that we conducted a formal engagement with the community to receive feedback and questions about what were their, the pain points or the areas of concern that the industry had. And in fact, we're developing that. We're finalizing it right now. So I do not have it, but it should be out in the later this year. But as a preliminary finding, what we saw is that the way that PIPA is crafted and the guidance that we have issued about how to take on these tasks have eliminated some of the potential conflicts between financial services regulation and data protection regulation that we have seen in other jurisdictions. And so what I mean by that is that there are exemptions for things like the detection of prevention of crime. There are exemptions for things like, if someone is a beneficiary of a trust. And then also, we have issued guidance to say that if you are following lawful, some other legal regulation, then that can be your lawful basis to use the GDPR phraseology for that. It also helps that there is a slight difference in PIPA in terms of the lawful bases, because instead of the legitimate interest test that you would see under GDPR, it's actually a reasonable person test. And going even further than that, it's would a reasonable person object to this use of information? And so it gives it, to my mind, that because we're shifting that test, it gives a slightly different, mechanism for using it than you would in the simple legitimate interest test, where you can say perhaps some things that get put under the legitimate interest GDPR test are more debatable, and so you don't run into that issue as much with PIPA.